Committee will come to order. Today, the committee continues its investigation of the credit rating agencies, companies at the heart of the last financial collapse, companies that will be at the heart of the next financial collapse. The average American has probably never heard of credit rating agencies, but these companies play a powerful role in our economy, and they played a starring role in the collapse of the financial system last year. The main mission of credit rating agencies is to tell investors how risky bonds and other debt securities are. Pension plans, banks, insurance companies, and others, investors depend on these ratings to help them decide where to invest their funds. Unfortunately, for the past decade, the credit rating system has not worked well at all. A year ago, this committee learned that ratings did not capture the true risk of many deals because the rating agencies were more concerned with their own bottom line than anything else. As one rating agency official said in an internal email, "We rate every deal. It could be structured by a group of cows, and we would rate it." The result was a marketplace flooded with toxic debt, so-called structured securities, such as CDOs and other complicated securitizations backed by risk mortgages and propped up by inflated ratings. More and more money was funneled into bonds and other debts that were destined to fail. Predatory lending flourished, which families got in over their heads buying houses they could not afford. Investors were left holding bonds and other securities that were dramatically overvalued. When the housing bubble finally burst, we wound up in the deepest recession since the Great Depression. A year after the collapse of Lehman Brothers and the massive government bailout of AIG, Bank of America, and others, it looks like not much has really changed. Today we will hear testimony from Eric Olshansky, until recently an insider at Moody's, one of the largest credit rating agencies. We have obtained a memo written by Mr. Olshansky to his superiors at Moody's detailing very serious allegations about Moody's rating practices. If true, these allegations indicate troubling behavior in the credit rating industry. According to Mr. Olshansky, they continue to use inaccurate and outdated models. They continue to have conflicts of interest, and they continue to rate novel securities with little historical data that no one really understands. He was not alone in having concerns about the new way Moody's operates. We will also have testimony from Mr. Scott McCleskey, who was Senior Vice President of Compliance at Moody's. Until he rocked the boat too hard, Mr. McCleskey's job was to ensure compliance with SEC regulations and other requirements. In theory, he was a senior executive with important responsibilities. In practice, he got the old mushroom treatment: keep him in the dark and bury him in fertilizer. In short, it looks like not much has changed since the crash of 2008. We ignore this situation at our peril. In the next financial crisis, will the credit rating agencies be part of the problem or part of the solution? Both the House and the Senate are drafting legislation to rein in these types of abusive practices by credit rating agencies. Our second panel of witnesses will provide suggestions on how to accomplish this. One other note, I would particularly like to thank my good friend Senator Alphonse D'Amato, the former chairman of the Senate Banking Committee, for being here today as well. Also, Floyd Adams, another well-known and highly regarded New Yorker. And let me conclude by saying I look forward to hearing from the witnesses. At this time, I yield to the gentleman from California, Congressman Issa, the ranking member of this committee.
Thank you, Mr. Chairman, and thank you for holding this hearing today. I strongly suspect that the gentleman from Pennsylvania to my left, Mr. Konjorsky, would rightfully so say, aren't we coming dreadfully close to overstepping the bounds of this committee and going into the territory well held by the Financial Services Committee? And I would agree with him up to a point. I would differ with him in one sense. Although the oversight of this part of the financial community clearly belongs to the Financial Services Committee, as does the SEC, transparency in government and transparency for the people who live under that government clearly falls within the jurisdiction of this committee. So as we review the failures in the financial crisis, I would say to my friend, the gentleman from New York, that in fact this committee must look beyond the failures of the public sector, or private sector in this case, look to the public sector, which we have direct jurisdiction over, and essentially we have the power today, which we didn't have back in the 1930s when the New Deal came about, and in a depression post-collapse era, the federal government began outsourcing the oversight and regulation and rating of credit instruments. Today, we have technology like XBRL and others, standards which we, the federal government, can insist allow for full transparency, not by the select few that we dribble and drabble out the ability to rate for pay, but in fact, we have the ability today to insist that every instrument made available to the American people can be transparent to the American people directly. We have the ability that instead of standing in line at your broker, you can go online and look at every element of that. That allows, of course, not every private citizen to necessarily do his own analysis. They don't do that on every stock or mutual fund. But it does allow literally thousands of educated people to scrutinize credit products and on a continuous basis evaluate the underlying risk that happens. In my own state of California, it's very clear. If you bought a bond 2 years ago, it's not the same bond it was today. You shouldn't have to wait for a credit agency to tell you California is in a financial meltdown in order to see a daily change. And you shouldn't have to do it if it's GE paper or anyone else's. So I would hope to work with the chairman on insisting a real change in reporting, one that eliminates these credit agencies as monopolies, duopolies, triopolies, or whatever a quadopoly is, and in fact opens it up to all the people of America. Additionally, as I said, this committee has broad jurisdiction, and I would hope that, as the chairman said this morning on CNBC, we would use it. I cannot agree more with the chairman for what he said today. He said people are now suffering. But, Mr. Chairman, why are they suffering? When you said we're going to look at the whole financial meltdown across the board, why is it we left Freddie and Fannie out? Why is it Franklin Raines, who apparently committed perjury before this committee, has not been brought back before this committee or referred for prosecution? Why is it that, in fact, Bank of America still holds vital documents showing 28,000 loans? Mixed in with them are hundreds or thousands of loans to government officials throughout the country, from the top to the bottom, from Republican to Democrat to Independent, who were clearly given what amounts to a bribe of government by a man who was brought before this committee because he made too much money while Countrywide stock was dropping, but has not been brought before this committee once we discovered that the Friends of Angelo program, in fact, was designed to influence members of Congress, key staff, and people throughout the government. That is not a small scandal. That is the crux of this scandal. If the trillions of dollars that the American people are on the hook for at Freddie and Fannie and as GSEs are in fact because Countrywide had a cozy relationship bought and paid for that allowed them to unload, not all, but much of these bad debts, and in fact allowed for the promotion of subprime and other risky instruments, then in fact, Mr. Chairman, that is the heart of the financial meltdown. The financial meltdown is not about the failure of the SEC. It's not even about Bernie Madoff and the billions that, in fact, he did opaquely without proper supervision. That's important, and we need to deal with it along with the Financial Services Committee. But the very underpinnings of good government require that government officials, when they take an oath to their city, their state, or our country, in fact, operate without an agenda bought and paid for by public or private money. It's clear that's not the case here. It's clear that the distortions in the market go back years, and they go back to government officials, quasi-government officials, and private sector, including, obviously, the Friends of Angelo program. So, Mr. Chairman, I challenge you today either to issue a subpoena to Bank of America to get those records, or allow this committee to have an open vote so the people of America can understand that, in fact, this is an important issue. It is not a side issue. It is at the crux of this very investigation. And I might note that when we began looking at this problem, when we had Angelo Mazzillo in front of us, there were tapes, digital copies of every single conversation between members of Congress, members of the administration, postal workers, Freddie and Fannie, even Franklin Raines, that were held so we could hear them. Today, I'm told they may have been destroyed. When I hear they may have been destroyed, I realize we have been lax in our duty since that chair was held by Mr. Waxman, and we had a crook in front of us that Mr. Waxman called a crook, said in fact that he was hurting the American people. Now we know in fact he bought and paid for what hurt the American people. Mr. Chairman, I call on you today to issue that subpoena. It is that important that I bring it up at this hearing, and I call for you, if you cannot do it, to step aside and allow the committee to have a vote, and I yield back.
Let me just respond to the gentleman. I see he's sort of worked up over that issue.
Yes, Mr. Chairman, I am worked up because we need to protect the American people. We won't do it if we don't investigate this corruption.
Let me respond by saying to you, number one, the Justice Department is looking at it.
Mr. Chairman, that's what the chairman of this committee said previously as an excuse. It turns out they didn't. It turns out the Senate Ethics Committee has failed to act and said, in fact, there was no ethical violation. We're beyond ethics here. We're at a point where the American people at least should know who they gave money to or benefit to, how they did it, and so on. We have ignored that paper. I have never seen this committee refuse to at least ask to see documents before deciding to ignore them.
Before we go to our witness, let me just say to you that I did not say the Senate Ethics Committee was looking at it. I said the Justice Department, so which is as you know, is a difference.
Mr. Chairman, if the Justice Department had subpoenaed the audio tapes, they would have them. They didn't, and it appears as though Bank of America allowed them to become destroyed, or they were destroyed in the last days of Countrywide. But more important, those documents, as we've been told, have not, in fact, been subpoenaed. The Justice Department does not have the boxes of documents that Bank of America has gathered but will not turn over without a subpoena for reasons of privacy. If you tell me today you're referring it because you have enough information to the Justice Department for prosecution or investigation, fine. But today we don't know what we don't know. What we do know is there was a level of intended corruption by Countrywide that clearly had an effect on government's decisions for years, and we are ignoring it. We cannot really understand the failure of government if we don't understand the failure of government officials led by, in fact, an attempt to bribe them.
The gentleman's time has expired.
Thank you, Mr. Chairman.
Let's move forward. Okay, we will now turn to our first panel of witnesses. It is committee policies that all witnesses are sworn in. So please stand and raise your right hand as I administer the oath. Do you solemnly swear to tell the truth and nothing but the truth? If so, answer in the affirmative. Right. You may be seated. Let the record reflect that they answered in the affirmative. Mr. Eric Olshansky is a former managing director at Moody's Corporation. He has worked in structured finance for over 12 years, 8 of which were at Moody's. While at the ratings agency, Mr. Olshansky focused on rating collateral debts obligations, CDOs. He has also worked at Lehman Brothers, Merrill Lynch, and MBIA in their CDO groups. We welcome you this morning. We also like to introduce Mr. Scott McCleskey, was the Senior Vice President for Compliance at Moody's Investors Service from April 2006 until September 2008. In this role, he was responsible for the organization's compliance with rules and regulations established by the SEC and other regulators. Prior to joining Moody's, Mr. McCleskey spent approximately 15 years in the financial services industry in both compliance and regulatory positions, the U.S. and in the European Union. Mr. McCleskey is currently managing editor for a firm providing news analysis and compliance solutions for the financial industry. We welcome you as well. Mr. Richard Cantor serves as the Chief Risk Officer for Moody's Corporation and as the Chief Credit Officer for Moody's Investors Service. In his role as Chief Credit Officer, Mr. Cantor heads the Credit Policy Group and chairs the Credit Policy Committee, both of which are responsible for the review and approval of rating methodologies. Mr. Cantor's Policy Group also works with the Rating Group at Moody's to promote consistent rating practices and improve rating quality. Let me welcome you as well. At this time, I ask that each witness deliver their testimony within 5 minutes. The yellow light means you have 1 minute remaining, and the red light means stop. Everywhere in America, red light means stop. And then, of course, we will have time to answer, raise questions with you and seek the answers. So we would like to start with you, Mr. Olshansky, and then come right down the line.
Good morning. I want to thank Chairman Towns, Ranking Member Issa, and all the members of the committee for giving me an opportunity to speak this morning. My name is Eric Olshansky, and during the majority of 2007, I was the Managing Director in charge of the business line, which rated subprime-backed CDOs for Moody's Investor Service. More recently, I was suspended by Moody's as a result of a warning I sent to the compliance group regarding what I believed to be a violation of securities laws within the rating agency. I'm grateful for the opportunity to speak in front of you on the need of rating agency and financial markets reform. Despite the circumstances of my separation, I still believe that Moody's is a good company, and the vast majority of analysts there are smart, capable, and want to do a good job of rating financial products. Unfortunately, these ingredients are not sufficient to produce quality ratings or to safeguard the financial system. While I do not believe that the rating agencies were the main cause of the credit crisis, there are other parties who are far more responsible. There are still unresolved problems which will lead to poor ratings performance. Number one, conflicts of interest. The conflicts of interest which ailed the rating industry remain unmanaged. Senior management still favors revenue generation over ratings quality and is willing to dismiss or silence those employees who disagree with these unwritten policies. Number two, Credit Policy Group lacks independence. The Credit Policy Group is a team of analysts whose role is to ensure that the methodologies and procedures used in the ratings process are sound and meet minimum credit standards. Unfortunately, the Credit Policy Group at Moody's remains weak and short-staffed. The group's analysts get routinely bullied by business line managers, and their decisions are overridden in the name of generating revenue. Inadequate methodologies. Methodologies produced by Moody's for rating structured finance securities are inadequate and do not realistically reflect the underlying credits. Rating models are put together in a haphazard fashion and are not validated if doing so would jeopardize revenues. Compliance Group lacks independence. The Compliance Group is entrusted with enforcing laws and internal policies. The group is understaffed and has little professional compliance experience. Instead of ensuring that the ratings process is free from conflict, this group sits idly by while these transgressions occur. In many ways, the incentives for rating agencies become worse since the credit crisis. There are now more rating agencies, and they are all chasing significantly fewer transaction dollars. The new controls put in place by regulators are too weak to significantly alter this dynamic. As an example of how little things have changed, ABS CDOs are being rated once again. These are the same products which are responsible for hundreds of billions of dollars of losses at major financial institutions. They are significant contributors to the problems at Citibank, Merrill Lynch, and AIG. I firmly believe that ABS CDOs cannot be rated with any certainty, and especially not during this volatile period in the capital markets. The new methodology used to rate ABS CDOs have not improved their poor credit performance. Many of the recent deals have been downgraded or have had to resort to restructuring to maintain their ratings. This toxic product needs to be consigned to the dustbin of bad ideas, but unfortunately, there are no incentives for rating agencies to say no to a product, no matter how poorly thought through. Investors like pension funds, insurance companies, and the Federal Reserve, who are required to purchase securities with certain ratings, deserve better than this. They need ratings which reflect an analyst's best judgment and not the profit targets of the agency. However, I believe there's a very simple and straightforward solution for the ills which haunt the ratings industry. It begins with the admission that the function which their agencies perform is quasi-regulatory. Fortunately, a model already exists which combines quasi-regulatory authority with private competition. It is the accounting industry. While accountants have not been free from scandal, the profession has not suffered the free fall in standards which have befallen the ratings industry. The key limitation is a single set of standards makes a lot of sense from a market and a regulatory point of view. It's much easier for regulators to learn and to pass judgment on a single set of policies rather than to understanding the minutiae and the particulars of multiple approaches. The same benefit applies to investors. A single set of criteria which is debated and promulgated in a public manner will greatly add to the cause of transparencies. I have witnessed too many instances of rating agencies talking their way out of a poor decision by confusing the listener with esoteric details of their particular methodology. If I were a doctor, I would diagnose the rating agency patient as very curable, but treatment needs to be urgently applied to avoid further damage. Rating agencies can once again be productive members of the financial community, but they cannot do this by themselves. They need a helping hand to get back on the right track. Thank you very much.
Thank you very much. Mr. McCleskey.
Thank you, Mr. Chairman, Ranking Member Issa, and members of the committee. My name is Scott McCleskey, and I served as Senior Vice President for Compliance at Moody's Investors Service, or MIS, from April 2006 to early September 2008. In that capacity, I was the executive formally designated as responsible for the organization's compliance with relevant regulations and internal policies. I've been asked to discuss my experiences with respect to the independence and authority of the Compliance Department. I will start by saying that in my time at Moody's, I had the privilege to work with a great many professionals of high ability and unquestioned integrity, and that in many cases, in many respects, things worked well. However, my honest assessment is that the compliance function came to lack independence and authority in some important respects. Before I go into detail, I think it is important to give a caveat that it has been over a year since my departure from Moody's, and until I was contacted by the staff of this committee a few days ago, I had not put a great deal of thought into these past events, so I'm at a slight disadvantage with respect to some of the specific dates and details. And for clarity's sake, I would point out that in keeping with the scope of the SEC regulations, my remit did not extend to the accuracy of the rating methodologies themselves. Until the end of 2007, I reported to an executive vice president, who in turn reported to the CEO. This executive vice president had responsibility for three departments: compliance, regulatory affairs, which generally handles relations with regulators and legislators on policy matters, and information technology. During this period, I would characterize the environment as generally supportive of compliance. In late 2007, my reporting lines were changed. From that point forward, I reported to Michael Caniff, who was made responsible for both my department and the Regulatory Affairs Department. Michael reported to the General Counsel, who reported to the CEO. So as you can see, an extra layer of management was inserted into my reporting chain, effectively moving the department one level further away from the CEO. Nonetheless, I remained as the formally designated compliance officer in all public SEC filings. It soon became clear to me that my authority and independence would be greatly diminished. In the interest of time, I will summarize my experience and concerns. Over the following months, experienced compliance officers on my staff were pushed out over my strenuous objections, and structured finance analysts without a single day of compliance experience were foisted upon me. Although I did come to believe that one of the new hires has promise, it does not balance the loss of 35 years of compliance experience from my staff. The hiring of structured finance analysts also creates a clear conflict of interest issue, since, like Michael Caniff, who came from structured finance, they could find themselves passing judgment on their own former practices and deciding whether to discipline friends or former colleagues, and potentially their own future managers should they return to their previous business units. Secondly, I found myself more and more frequently excluded from decision-making meetings concerning potential violations. I will note that this did not occur on each and every occasion, but it did so with increasing frequency and in particularly important matters. This includes an examination conducted by the Securities and Exchange Commission, which was handled by our legal department and by outside counsel. I was flabbergasted that I, the designated compliance officer, would be excluded from meetings with the SEC during an examination, and was vocal in making this point. A common answer whenever I would object to these exclusions was that it was necessary in order to preserve attorney-client privilege, although it is my understanding that other non-legal department staff were included in these meetings. This focus on preserving confidentiality, I believe, also led to the sometimes explicit and often implicit directive not to put anything in writing that could be used against Moody's in litigation or regulatory proceedings. My time at Moody's came to an abrupt end a little over a year ago when I was dismissed without any specific reason other than senior management no longer has confidence in you. This came as a bolt out of the blue. At no time had Michael or the General Counsel given any indication of dissatisfaction with my performance. Moreover, a few weeks before I was pushed out, I was given responsibility for addressing the issues raised by the SEC following its examination, the one I had been excluded from, following which Michael went on a previously scheduled and I think well-deserved vacation. I hardly think that an organization which takes its regulatory responsibilities seriously would give such a critical project to someone it had lost confidence in. I am left to speculate on the real reason for my departure. 1 hour after my departure, it was announced that I would be replaced by an individual from the Structured Finance Department who had no compliance experience and who, to my recollection, had been responsible previously for rating mortgage-backed securities. I do understand that he has been replaced now by somebody with compliance background, and if that's the case, I hope that person has the authority that I lacked in the organization. The matter before you regards how credit rating agencies should be regulated in the future, and I will make two brief observations before closing. First, my experience leads me to recommend strongly that the regulations be amended to require that the designated compliance officer report directly to the CEO or to the board of directors, and that this person not have come from one of the business lines within that organization within the last 3 years. Secondly, with respect to the notion of removing reference to NRSRO ratings from federal regulations, I would recommend caution. At present, NRSRO status is the only hook by which regulators in the United States are able to exercise oversight of credit rating agencies. If NRSRO status is made irrelevant, I would urge you to ensure that other measures are taken to continue this important oversight of these important agencies. Now, Moody's will undoubtedly respond as they habitually do, that I'm a disgruntled ex-employee who has an axe to grind. To this, I will simply respond that it has been a year since my departure, and I did not actively seek the opportunity to testify today. By putting my head above the parapet again, I am likely burning a lot of bridges with former colleagues whose esteem I value. I am putting my family through stress that could be avoided very easily by simply saying, I don't know anything. Thank you for your time.
Thank you very much, Mr. McCleskey. Mr. Cantor.
Good morning, Chairman Towns, Congressman Issa, and members of the committee. I'm Richard Cantor, the Chief Credit Officer for Moody's Investors Service. I welcome the opportunity to contribute Moody's views to this hearing. I'd like to begin with a brief overview of Moody's ratings process.
Mr. Chair. Yeah.
At the start of the ratings process, an analyst gathers relevant information from issuers and public sources. He or she then conducts a credit analysis applying Moody's methodologies, which are publicly disclosed and freely available on our website. After forming an opinion, an analyst brings his or her analysis to a rating committee, which is a critical mechanism in promoting the quality, consistency, and integrity of our ratings process. The committee discusses and then votes on the appropriate rating for the security. One of the core principles of this process is that different analysts can and will legitimately hold different views on the credit risk based on the same set of facts, and the committee process is the vehicle for resolving these disagreements. Once finalized, credit ratings are communicated to the general public free of charge. We monitor these ratings on an ongoing basis, and we modify them if our view of the creditworthiness of the issuer or the obligation changes. The unprecedented credit crisis that began 2 years ago has provided important lessons for Moody's, other credit rating agencies, and all market participants. In light of these lessons, Moody's has adopted an array of measures to enhance the quality and transparency of our credit ratings. These steps include changes in the following 5 key areas: strengthening the analytical quality of our ratings, enhancing consistency across rating groups, bolstering measures to manage conflicts of interest, improving transparency of ratings in the ratings process, and increasing resources in key areas. We believe we've made important progress, but more can be done. Indeed, Moody's supports a number of reform proposals currently under discussion that can help restore the credibility of credit rating agencies and return confidence to structured finance markets. We also believe that other steps could be taken to increase disclosure in structured finance markets. Specifically, we believe that increasing information disclosure by issuers, sponsors, and underwriters of structured finance securities would yield 3 principal benefits. 1, reduce the risk of over-reliance on credit ratings. 2, improve the information available about structures and assets. And 3, broaden the range of opinions and analysis available to the market. Finally, let me turn to the allegations raised by Mr. Olshansky in a letter sent to this committee. Mr. Olshansky has raised a series of evolving claims over the past year, and in July, Moody's retained the outside law firm Kramer-Levin to conduct an independent investigation of all of these issues. It's important to note that Moody's didn't direct the investigation. Rather, the company gave the independent law firm unfettered access to our personnel and documents. I understand that the outside lawyers have interviewed 22 Moody's employees, and the only person who's refused to meet with the investigators is Mr. Olshansky. As the committee is aware, Moody's, in anticipation of today's hearing, also asked the independent law firm to provide the committee staff with a briefing on the preliminary findings of that investigation. These findings have also been shared with our regulator. I understand that the committee has been informed that these preliminary conclusions are consistent with Moody's own internal review. Specifically, Mr. Olshansky's claims of misconduct are unsupported. Instead, Mr. Olshansky raises issues of long-standing and healthy debate within the company and the credit rating industry. When debates have been resolved contrary to Mr. Olshansky's personal views, he has alleged that the process was fraudulent, unreasonable, or otherwise improper, when they were not. All of us at Moody's are committed to meeting the highest standards of integrity, quality, and transparency in our rating practices, methodologies, and analysis, and we will take all the appropriate steps to uphold these standards. I'm happy to respond to any questions.
Thank you very much, Mr. Cantor. Let me begin by raising questions, and each member will have 5 minutes to do so. Mr. Olshansky, I have here a memo you wrote to Micah Caniff, the head of compliance at Moody's. In the very first sentence, you said Moody's was engaged in illegal conduct. What kind of illegal activities was Moody engaged in?
Sir, I believe that Moody's violated securities laws by issuing ratings on 9th grade funding in January. They knew that the ratings were incorrect. They had knowledge of it, and yet they still went forward and issued the rating. It's not, as Mr. Cantor states, a matter of policy. It's a matter of law, whether you can or not, knowing that the ratings are wrong, actually opine on a rating. And that's what I believe was the violation of the law.
But did you warn Moody's of the problem?
Yes, sir, I did. I had, in the past, Moody's came very close to doing something very similar, and that was September '07. And at the time, I was able to prevent the occurrence of that from happening. I had warned both the compliance group and the credit policy group about these issues, and about precisely this type of an action leading to securities laws violation, and those warnings were ignored.
Is it true that you also warned Moody's that the ratings procedure used by derivatives groups were inadequate?
Yes, sir, I did. I believe specifically this relates to the new methodology for rating ABS CDOs, which was used in the process of rating the deal in question here. I had told Mr. Cantor's group, and I had told the compliance group that the methodology was not realistic. It had many problems. It was not based on real-world scenarios or real-world views of how the credit would perform.
Right. Is it true that you warned Moody's that the ABS CDO methodology used by the derivatives group produces misleading ratings that will continue to destabilize the financial markets as well as cause losses for investors and shareholders?
Yes, sir, I did that.
Mr. Cantor, I understand that Moody's hired an outside counsel, as you indicated, from the law firm of Kramer Levin to investigate Mr. Olshansky's allegations. I want your commitment that Moody's will provide to this committee within 1 week copies of all documents that were provided to Kramer Levin regarding their investigation, along with a copy of the preliminary report which they issued just yesterday. Will you make that commitment right now?
Mr. Chairman, I will pass along your request to the appropriate people at Moody's, and I'm confident that they will be able to comply.
I don't quite understand, other words, aren't you appropriate? You're testifying here, and you're under oath.
Yes. I am the Chief Credit Officer. I'm responsible for the methodologies that we produce and use in the ratings process, and I will communicate your request to the appropriate people at Moody's, and I am confident they will comply.
Yeah. Well, who are the appropriate people?
I would expect the General Counsel at Moody's.
I'm sorry?
The General Counsel at Moody's.
Right. Okay. Thank you. Mr. McCleskey, I have a letter you wrote to the SEC in March of 2009. In it, you warned the SEC about Moody's municipal securities ratings. Are these ratings just out of date and inaccurate? Is it true that Moody's did not warn investors these ratings were out of date? Mr. McCleskey?
Yes, sir. In that letter, the intention of that letter was to alert the SEC so they could look into a situation which I was aware of, in which there are tens of thousands of municipal securities out there that just due to the sheer number, they're not getting the same level of scrutiny, surveillance on the ratings that you would expect from a normal bond or structured instrument. There were concerns. I had expressed concerns about this because my feeling is that there will be municipal bonds out there that haven't been looked at that may have out-of-date bond ratings that the public may not be aware that these are out of date. It's one thing for the bond to be the city of New York or California where everybody knows the economic state, but these include very small school districts or very small municipalities where it may not be as available to the public. Now, I'm not an economist, but the SEC has economists, and that's the reason why I raised this issue, and I urged them to include a review of this in their next routine examination. And I do believe that that's important. It's been, as I said, a year since I was at Moody's. Maybe things have gotten better. I hope they have. But at the time that I wrote this letter, I felt that it was something that the SEC needed to be aware of.
Thank you very much. My time has expired. I yield 5 minutes to the gentleman from California, Congressman Issa.
Thank you, Mr. Chairman. And I'd like to follow up on the Chairman's statement to Mr. Cantor, or a question. To your knowledge, since you supplied a great deal of the information that went to the independent investigation, is most of it information which you would consider not to be attorney-client privilege?
I'm not familiar.
In other words,
with
the
rules
information that you
regard
provided was of a statistical and numeric nature. It was emails pertinent to today's discovery. In other words, it was information that should not be withheld based on a claim of attorney-client privilege. Would you agree?
I have no expertise in this area.
Well, then I'll break it down a little bit so the chairman and I are consistent on this part. Was most of this information internal emails and correspondence related to today's hearing that would either affirm or deny Mr. Olshansky's claims?
I'm sorry. I'm not sure I understand the nature of the
It's real
question.
simple. Today, you weren't able to answer, and you're referring to General Counsel. My concern is you go back to General Counsel, and they claim a broad attorney-client privilege, and then we play that 20 questions games in a subsequent hearing where I guess we bring your General Counsel in. I want to understand today what it takes to investigate a claim by a whistleblower. We're presuming, but I want an affirmation, at least to your knowledge, doesn't appear to be specific attorney. You did not turn over, as far as you know, lots of things by your attorneys to this independent group, which we would presume, if they're independent, they're not going to claim attorney-client privilege just because you paid them.
The firm that conducted the investigation had unfettered access to all of our
I'm only asking if they had
so there
independence.
was no specific materials that were turned over.
Okay, so if I understand correctly, today the chairman and I are going to close the hearing based on the hope that Moody's will turn over what the chairman has asked for, and if they don't, then we have to go back through the process of your claim that they're independent, just as Moody's is independent when they issue credit ratings, and yet you paid them and therefore have an ability to claim attorney-client privilege and may.
I expect there will be a full compliance with the request. I'm
Good.
only pointing out
That's
that
what we
I am
expect.
not an expert in this area, and you're speaking to someone who
Okay. Well, the
can
chairman and
only
I will be patient on
conjecture.
that issue, but I wanted to clarify because I'm deeply concerned that the word independent and outside generally means they were done for our benefit and the people's benefit, not just for the person paying them, which gets us back to Moody's. Do you believe that this very narrow, I guess 4 groups that are allowed to do what you do is reasonable or sustainable? In other words, is there any reason to have an oligopoly or oligopoly, to use a now Russian word, it seems, or could we have dozens of organizations allowed to try to do what you do, and then if you do it better, you would rise, and if you didn't, somebody else who was more accurate would rise? Is that a better way for this committee to look at the future, or should we continue with this narrow group that we trust even though they failed us?
Well, Moody's favors a vigorous competition in the credit rating industry. There are currently perhaps 100 credit rating agencies around the world. Perhaps I don't know how many there are in the United States.
Well, let's just say that the big 3 have 90%, and in the electronics,
NRSROs.
the last 10% isn't enough for anyone to matter. So if 3 of you have 90%, you have a 3-way monopoly.
Well,
So let me follow up with another question. This committee has promoted, I think vigorously, transparent reporting systems. XBRL is one of them, obviously well along the way, and a nonprofit. Would you believe that this committee should, in fact, make that a public policy so that broadly this information that is not available to the individual consumer or individual investors could become available?
Moody strongly supports enhanced disclosures in securities markets, including the type that you have proposed.
Okay. For my whistleblowers, and thank you for being here today. I know it's tough, and I know there are always the other side whenever someone comes forward. But let me ask you a question. Currently, Congress is considering giving more authority to the SEC to do what they didn't do when you reported to the SEC. Does that seem like it makes sense to you? If they didn't act when you reported, should we simply give them should we rely more heavily on government, or should we have, as I'm suggesting, XBRL and other ways for people to second-guess reporting? Either one of you.
Sir, if I could go first. I think that transparency is generally a good idea, but
Pull
there
your
needs to
mic
be
just a little closer to Mr.
Beg your pardon?
McCleskey. Will you pull your mic closer to you? Yeah.
Is this better? I think a distinction needs to be made between transparency and disclosure. In my mind, disclosure is providing information. Transparency is providing it in a meaningful way. I would also draw a distinction in your example with respect to stocks and bonds. I agree with you that many people do not research the stocks and bonds before they buy them, but I would assert that that is because they don't wish to. If you're putting out information about a structured finance product, there may be people who wish to conduct an analysis but lack the expertise, the models, the methodologies to do so. So I would make that distinction. Should the SEC have more authority? To my knowledge, they have not done their first routine cyclical examination of the firms yet. I think that the reason for that is, frankly, this is an unregulated industry for the past century. They have needed time to get up to speed. I would frankly have expected something to happen by now, but I think that with respect to the aggressiveness of the SEC with respect to the credit rating agencies, I would suspect that part of that is simply because they are getting staff up to speed, they're hiring staff. I wouldn't write them off just yet.
Gentleman's time has expired.
I would agree with Mr. McCleskey. I think the SEC has had a difficult role, especially since each agency has its own methodology. I'm very familiar with my methodology that I was responsible for. It is very difficult to understand. It has a lot of minutiae, lots of twists and turns. I think what I proposed as a public body along the lines of FASB, where these decisions would be made in a public manner, which would be overseen by the SEC as FASB is, but where these decisions are overseen in a public manner, the types of data that goes out, it goes out to everybody, and decisions are made publicly with public consent. And I think that would be the best way of opening up this industry to transparency.
Thank you, Mr. Chairman.
Thank you very much. I now yield 5 minutes to the gentleman from Pennsylvania, Mr. Kanjorski.
Thank you very much, Mr. Chairman. Mr. Cantor, in your testimony, you sort of asserted with great pride that the information is made available to the general public free of charge. And there's nothing incorrect about that statement, but do you mean to indicate that nobody pays for this information?
The information about our ratings?
Yes.
That's correct, that the distribution of ratings to investors is free of charge.
Yes, but are you going to tell us who pays for it, or are you going to just indicate
who pays for
that it's free of charge?
The effort
You're an Ealing-Mosnary corporation, I assume.
Sorry.
You don't charge, you do this for free?
Yeah. No, we are paid by issuers of securities in the capital markets for the ratings we assign.
That's surprising. Now, I'm just going to pose a question to you, and I hope you could give me a reasonable response. If we went to our colleagues in the House and the Senate and told them that we have discerned a new way to reduce the budget of the United States by significant proportions, and that is we could remove all the expenses for the judiciary branch of government because we've come up with a new formula that all lawyers who represent winning litigants have agreed to pay the judges' salaries. Would you sort of conclude that that's a good and fair and proper way to carry on the judicial system of the United States?
I must admit the hypothetical is a little confusing to me. But I imagine you're proposing something that you feel is a very bad idea. I must admit I got a bit lost.
I'm proposing what occurs in the rating agency. You get paid by the issuers, don't you?
We do.
Well, you didn't want to indicate that. You were bragging about that the public gets it free of charge. That can or cannot be true. If it's an incorrect or prejudicial rating, it's not free of charge. It's the price we would pay for that was exactly what happened a year ago. The markets would have bad securities, some people call them toxic securities, and it could in fact cause a crash to occur, which in fact happened. Now, I'm not saying that we can trace it directly to the rating agency, but that's a possibility. So that wouldn't make it free of charge. That would make it extremely expensive. Do you agree?
The Moody's has been operating under the issuer pay model that we were just talking about for 40 years. And we have a long track record under this business model that we stand behind and is the basis of our performance.
One of your colleagues in testifying said they wanted to operate like the accounting businesses, that they don't have any problem? Maybe you have a short memory. Do you remember a company called Enron?
Yes, sir.
What was the problem that we found in Enron?
Sir, I believe it was fraud.
No, we found that Enron was being paid exorbitant fees for consulting services, and those fees had a tendency to affect their professional opinions as accountants. This exact conflict of interest that exists in this rating agency problem today. Now, I appreciate if you are whistleblowers that you came through, but I listened to both of your testimony and I didn't hear anything terribly shocking. If this is the best testimony that we have, I'm surprised that Moody went out and hired the lawyer that they did to attack you. You haven't given a course of conduct, in my opinion, of fraud. You haven't given a course of conduct of real gross neglect or negligence. You said there are some instances, like the supervisor was not allowed in the room to meet when the SEC came by. Maybe good, maybe bad. We should wrap their knuckles, but there's nothing criminal about that or really extreme about that. And in your instance, what do you find after all these years of issuing these opinions? You said they did things that violated the law. What did they do?
Sir, I believe they violated Rule 10b-5 of the
Do me a favor,
Securities
speaking to
Exchange
the mic.
And
Apologies. I believe they violated Rule 10b-5.
10b-5, and what's Rule 10b-5?
The Rule 10b-5 is fraud, securities fraud, in the securities markets.
And how did they do that?
Sir, if I might, I can quote from a memo that was produced on behalf of Moody's by another prominent New York law firm, written to the SEC, and they state a rating agency would be liable, this is with respect to 10b-5, if it knowingly published a report that falsely misrepresented its own evaluation of security, and that's exactly what they did.
And how did they do that?
Sir, they knew that the underlying ratings, this was essentially a CLO squared. In December, they had just decided to change the methodology on the underlying CLOs. And they knew, in fact, that all those ratings were now wrong. In fact, they ran internal tests that showed that securities that were rated below AAA would be moved 3 to 6 notches. Okay. That knowledge must have been incorporated in any new rating. Okay. Once that was decided, once the step was taken, it should have been decided if you're going to base your other ratings on those ratings.
Right. Okay. Now, was that directly reported to the appropriate officials at the SEC, or how was that handled on your part?
How was my complaint handled?
You found out that they were using false information that they knew was false, so knowingly they did this.
Yes, sir. I was not a part of this. I reported it to a compliance group as I was supposed to. Once I was.
What do you mean you were not part of this?
I was not in the rating agency.
Well, how did you find this information?
From speaking to colleagues and off of.
So this is hearsay.
Yes, sir, but it's backed by documented evidence which is available.
Did those colleagues that told you this then report that to appropriate officials either in the Justice Department or the SEC?
I don't know, sir. Didn't
you figure out it may be important to determine that?
Sir, I'm just a single person trying to do the right thing. As soon as I knew anything, I reported to my compliance group. After my suspension, I tried to report to the SEC, and I also spoke to the committee here. But I believe I've tried to make sure that these matters were brought up to the attention of the appropriate parties.
If I just ask one question of all three panelists.
Yeah. Ask unanimous consent to give the gentleman another additional minute.
You've heard the example of how rating agencies are paid by the issuer, which poses potentially great conflicts of interest. Do the three of you have opinions whether we should examine into this and change this practice, or do you think it's working perfectly well and has no effect on what the rating agencies are doing in the marketplace?
Sir, I think the conflict of interest at the rating agencies is much more pedestrian. It's more a short-term profits versus long-term credit quality. There's nothing special issuer pays or investor pays. It's a short-term profit focus conflict of interest. And in many cases in my world, in ABS CDOs, one of the reasons you're seeing all the banks like Merrill Lynch, UBS, and Citigroup have problems is because they retained the vast bulk of the debt that they issued. So it was effectively an investor-paid model. They couldn't get outside investors to buy the stuff, so they kept retained the deals on the balance sheet. So it's very difficult to actually implement a good investor-pay model that would not have the same conflict of interest if the investor has the same incentives as the banker does. In the case of ABS CDOs, in many cases, the investor and the banker were the same party, and they just brought it on the balance sheet because they wanted to show revenue. So theoretically, I agree with you very much.
Do I understand your testimony to say it doesn't make a difference who pays? It has no effect on the end
No,
result?
of course it does. Of course it does. My testimony is that in practical terms, it's very difficult to find the ideal investor. Not every investor is a Warren Buffett.
I didn't ask you the question about whether investors should pay. That's our big problem, who should pay or who can pay, and why we got to this peculiar system that we have. That's what we're examining into.
Yes, sir.
I don't want you to conclude we think that's the better system. I want to ask you, do you see the gross potential conflict of interest when the person issuing the security pays for the person who rates that security?
Yes, sir.
Okay.
Sir, I think I would agree with Mr. Kolchinsky, and I do see the gross conflict. The problem then becomes what do you replace it with. And I don't have an opinion. I'm not smart enough to know the answer to that question.
Neither are we. That's why we're working on it.
If I could, I think I should also respond to your other point about whether it's important that I was or was not in a particular meeting. The compliance officer position is embedded in the law with respect to credit rating agencies, as it is in many other sectors of the financial industry, and for good reason. These are the people that are supposed to be independent and supposed to keep their eyes open for any potential violations. If that position is not properly resourced, does not have enough authority, then that puts the firm, that puts the industry at risk. And so this is not just what you would have in normal office politics. This was something that, in my view, weakens the oversight of the credit rating agencies.
All right. Mr. Cantor?
We believe that any rating agency system in which a party that obtains the rating and is interested in the outcome of the ratings process model or an issuer pay model presents a potential conflict of interest which must be carefully managed. There are a variety of rating agencies using different models to carefully manage our potential conflicts of interest to the highest possible standards. We've been engaged in this particular business model for 40 years and produced a strong track record. We actually have historical experience of operating under an investor pay model for the previous 60 years, which we can reflect back upon and compare our performance, and we have, to how we performed under that business model compared to the model we adopted around 1970. And the historical data indicates that our performance has been stronger since that time, both in terms of the way we've been able to rank order the probability of loss across different credits, and in terms of the losses that would have been experienced by investors who bought all the securities that we rated investment grade in the two different periods.
The gentleman's time has expired.
Thank you,
I now yield to the gentleman from North Carolina, Mr. McHenry.
Thank you, Mr. Chairman. Thank you all for testifying today. This is certainly important in light of the financial crisis we've faced over the last year. And on the Financial Services Committee with my colleague, Mr. Kanjorski, we've gone into the causes of this crisis, and I think there's a wide agreement that the credit rating agencies were complicit in this crisis. For a number of reasons, some of which were errors and omissions, others outright fraud by those that are disclosing information to the NRSROs. So, Mr. Kolcheski, you believe that corruption was a major, played a major role in this crisis, is that true?
Sir, I wouldn't call it corruption. I would just say very poor incentives.
Okay.
Were the major part of.
Okay. Do you believe that a weak analysis of these new complex financial products was a part of it as well?
I think so as well. More could have been done and should have been done in 2020 hindsight that could have analyzed these products. The main part of it is a lot of people just should have said no to some of these products. And that's 2020 hindsight, but I think that's the major part. Just said, we can't analyze this with any degree of confidence, we should just walk away from it. But that was just not possible.
I think there's probably agreement on the panel that, reforms need to be instituted. I mean, I think that's fair. Even Mr. Cantor gives a small nod. But of particular interest to me as a policymaker on the Financial Services Committee is whether or not giving the SEC the authority to outline the minimum information that issuers should provide the NRSROs. Is that a worthy policy that we should put forward in empowering the SEC to specify what information needs to be given to credit rating agencies? Mr. Kolcheski?
Yes, sir. I think it's important for a body to set could be a private, public, self-regulating organization like FINRA, to set minimum standards that are applicable across the board for data that can be provided. And there should be some government body that passes judgment on that, whether that's sufficient.
Okay. Mr. McCluskey, and then we'll get to you. We'll finish with you, Mr. Cantor. I'm asking Mr. McCluskey first, then we can finish with you, Mr. Cantor.
Yes, sir. I would first have to say that this is more within the remit of my colleagues, but I would say this from my own experience with regulations here and in Europe, that I'm generally in favor of this, but you have to be careful that if you set minimum standards, there's sometimes a tendency that people will only do the minimum. And I'm also familiar enough with the complexity of the market that there will be different types of information that will be appropriate for different types of securities. And as the universe of rated securities expands, that will be difficult. So there will be challenges, but having said that, I am in favor of it.
Mr. Cantor.
I would be opposed of the idea to create minimum standards for disclosure to rating agencies. I think minimum standards for disclosure should be to the general public. I don't think we want to privilege rating agencies with special access to information based on government decision making. That there's a wealth of analysis that's done on fixed income securities by rating agencies, by investors at large asset management companies, and in the financial press and by academics, and I think it would be a very bad idea to have specific rules for what should be shared with credit rating agencies.
Yeah, I think what I'm saying is what is rateable, what information should the issuer provide to rating agencies in order to provide a rating? I think you're answering a different question.
I'm sorry, maybe I was just particularly struck by the notion of what should be shared with the rating agency. I do believe there should be minimum standards for information disclosure generally, including to rating agencies.
Okay, it seems like you're
answering. And it should be expanded for structured finance securities from where it is today.
Okay, it seems like you're answering a different question originally. Yeah, I'm saying basically what is holding you accountable, what is holding your client accountable to provide accurate, full, and complete disclosure. Because otherwise, then the credit rating agencies are simply incompetent and didn't see a financial crisis coming if you're saying that, you got complete information.
Right.
Is that fair?
Right. You're correct. The standards for what is required for an issuer to disclose publicly is very different in structured finance than it is in corporate securities. And the potential liability of the issuer of such securities for false disclosures is different, and the completeness of those disclosures, the requirements regarding completeness, is very different. And
so then you are in favor of the SEC providing those minimums by which the issuer should provide the NRSROs?
The NRSROs and the general investing public.
Sure. Yes. Thank you.
Thank you very much. I now yield 5 minutes to the gentleman from Ohio, Congressman Kucinich.
Thank you, Mr. Chairman. I want to thank you for holding the hearing. through the housing crisis and larger financial crises, the credit rating agencies seem to have otherwise escaped any real scrutiny. I've been troubled by the increasing popularity of instruments called REMICs. Now, what this stands for is re-securitization of real estate mortgage investment conduits, and the shorthand is called REMICs. And it basically amounts to repackaging original investment instruments that no investor will touch into more complex investment vehicles. Now, Mr. Kolchinsky, are you familiar with these REMICs?
Yes, sir, I am.
Mr. Cantor?
Yes.
I wrote a letter, Mr. Chairman, to the chairman of the SEC, Mary Shapiro, and I've spoken to her about this issue. And here's what I've learned. The total resecuritization market right now is approximately $664 billion. Of that total, only $60 million is considered registered transactions. That means that the SEC has looked at only $60 million. The vast majority of the transactions are exempt from registration with the SEC. But, Mr. Chairman, do you know who does look at these resecuritized real estate mortgage investment conduits? The REMICs? Credit rating agencies. So here we have a group of companies who played a substantial role in bringing our economy to the brink of collapse, and we have to ask if they're doing it again. Financial institution takes some toxic assets that no one wants, crams them together into a more complex instrument, and presto, according to rating agencies, you can have an investment-grade product. The practice of securitization gained popularity as a way to provide liquidity to the mortgage market and hedge against risk. Apparently, the financial services industry has learned nothing from our housing crisis, because the rationale behind resecuritization is to provide liquidity to the mortgage market and hedge against risk, and the credit rating agencies, paid by the issuers, are all too happy to oblige. Now, Mr. Kolchinsky, seeing as that the REMICs are more complex, more opaque than the collateralized debt obligations, the CDOs that came before them, what's to stop these re-securitization of real estate mortgage investment conduits from bringing the entire system to the brink once again? What does the SEC have to do to protect against a new disaster in the securities market?
Sir, I think...
Could you speak closely to the mic?
Apologies. I agree. I think some restructuring...
You agree?
I agree that these REMICs or repacks, as they're called, are potentially dangerous. Some have a purpose. That purpose may be a gaming of capital requirements, accounting requirements, or what have you.
Gaming?
Yes, sir. Recently, I've actually saw a repack that was proposed that had absolutely, to my view, no discernible economic value. Substantial costs would be incurred, but to my knowledge, there would be no value added. So to me, that's a sign that somebody's playing a game with some regulation somewhere. I'm not just not.
So
you
you would agree there is a danger here?
Yes, sir. Yes, sir.
And then what about the role of credit rating agencies? If someone tries to assess what the value of a resecuritized real estate mortgage investment conduit is, they go to a rating agency, right?
That is correct.
And is it in the interest of the rating agency to try to find a way to give a rating so that they can get these things out on the market?
That is correct.
And Mr. Kolchinsky, that's even if you have just a bundle of toxic assets where the value of it might be washed away, essentially.
Yes. There's these can be very problematic. Some REMICs that were done last year went from AAA to C or CA by Moody's.
Well, and Mr. Kolchinsky and Mr. Chairman, in light of that, and we may want to do another hearing on this point, Standard & Poor's has already downgraded these REMICs that they rated less than 5 months ago, due, and this is a quote, to the significant deterioration in the performance of the loans backing the underlying certificate, unquote. So the bottom line, Mr. Chairman, these are homes. And these are families and communities, our constituents. Got to watch these credit rating agencies. They could be setting us up for the same thing all over again. And I'm glad you're holding this hearing, Mr. Chairman. I hope we can get into this deeper. I yield back.
Thank you very much. I'd like to thank the gentleman from Ohio for his words. From the state of Missouri, Mr. Lukemeyer.
Thank you, Mr. Chairman. Appreciate the opportunity to discuss this issue today. Before I get started, I would like to echo the comments and sentiments of the ranking member with regards to the subpoena of documents to be able to further investigate and hold accountable those entities that he was discussing a while ago, and would hope that you would certainly respond to his request. With regards to the gentleman before us, as a former bank regulator, I can assure you that when we look at the investment portfolio of the financial institutions, your ratings are extremely important in our analysis of their financial structure and the liabilities that they have on the books and the assets they have on the books. And so for us to have this hearing today with regards to the viability of your ratings is extremely disconcerting to me from the standpoint of what's happened and how important they are not only to the banks but other investment firms and the general public as a whole. I guess my question to Mr. Olshansky is initially, and Mr. McCluskey as well, is why do you believe that this happened? What is the incentive for the ratings agencies to not do their job correctly or to stray from the practice of doing the job they should be doing?
Sir, in my view, it's slightly the opposite. There's no incentive for them not to. There's no incentive, and to me that's the benchmark for the whole industry. There's no incentive to say no to a transaction.
Then why did they do it?
For revenue. The rating agencies are large institutions with large fixed costs, and people get in a transaction in the door. It's very difficult to say no to that transaction, especially if that means you can take that revenue. You say no to it, you can take it to another rating agency. There's now 11 rating agencies. You can take it to another one, somebody who will say yes.
So what you're saying is Congressman Kanjorsky's comment to the question of the agencies being paid by the very people who they are rating these securities for is an inherent problem, and that is probably the reason for some of the problems we have here. Is that what you're saying?
That's right, sir. But the problem is that the person can also select which rating agency they go to. Okay. And they're free to go one or another until they find one that will help them out. And again, these are
so there's really, I guess the question, it begs the question: how rampant do you believe the inadequacies or their willingness to look the other way, or their willingness to do an inadequate job in lieu of our far further profitable gain is there? I mean, is that the general method of operating, or are there some inherent? Are they're normally trying to do a good job, or they just see a big client? We've got to skew it so we can make a few bucks here.
Sir, I don't believe it's direct. I believe what happens is that you have a client, you have a business, and people talk themselves into being able to think that they can understand a deal, can understand a structure, and be comfortable with it. I do not believe in most cases that any of this is a direct willingness to do something wrong. In most cases, it's getting comfortable with something that may be outside of the envelope, and there's usually small little steps all the way down. It's a slippery slope.
Okay, Mr. McCluskey.
Sir, it would be speculation on my part to guess why organizations are following particular paths, but I will make 3 points. First, I would just observe that, especially earlier on in my time at Moody's, I will simply say that the senior management of the structured finance group was very proud of the amount of revenues they brought in, quite vocally. And that's all I'll say on that matter. Also, I would say with respect to incentives, organizations don't make decisions, people do. And I think we need to take a look at the incentives that fall on the individuals. And Mr. Cantor will point out, and rightly so, that ratings are arrived at by committees, but committees are led. committees are made up of individuals. And I think that you would actually have to look not just at, for instance, the compensation practices, but you should also take a look at things like the performance evaluations. What are the criteria on which key people are being evaluated? Yes, sir.
Okay. Very quickly, my time's running out here. I got one more quick question for you. Because it seems to be a prevalent problem with all the rating agencies, is there collusion between the agencies? Have you seen that, or are you aware of that, or would you speculate on that?
I am not aware of any, and I would actually say that there were a lot of efforts to make sure that there wasn't even the appearance of collusion.
Okay.
Would the gentleman yield?
I
Yes.
agree with that. So,
Yes, I'll yield. Thank you. Thank you, Mr. Chairman.
Yeah. The model you have is the same model that basically PricewaterhouseCoopers, Ernst & Young uses. You pay to get an audit. Why is it yours appears to have failed, where audits by comparison, particularly after Sarbanes-Oxley, have been considered to do better?
Sir, I believe it's the existence of a minimum standard. The problem is rating agencies today are judges and juries and executioners of their own methodologies. And it's very easy for them to go down a slippery slope and to change methodologies and adjust it in order to get a client. If you can imagine, for example, if an accountant could go to a potential client and say, you know, your current auditor thinks that this is a loss, but we think it's a gain. According to our methodology, it's a gain. If you hire us, bring us in, pay us money, we'll do your books, we'll make sure that that's a gain. You would see standards fall precipitously across the industry. Accountants can't really do that. And moreover, because there's a minimum standard, if they do deviate from that, it's a clear case of fraud or liability. That's one of the reasons I think you do see some fraud cases, but it's very clear when fraud has occurred, and you can take action in those cases.
Right. Gentleman's time has expired. I now yield 5 minutes to the gentleman from Illinois, Mr. Quigley.
Thank you, Mr. Chairman. Mr. Cantor, you began by talking about some of the improvements you thought your firm had made in the last year. I guess you had specifically talked about changes in methodology. Your expertise would be methodology. Can you specify from where we were at a year ago how your firm has changed, or methodologies that they no longer use that someone might have questioned at that time?
Well, I'll point out two examples.
And I'm sorry, could everybody move their microphone closer, because especially over here it's just very hard to hear.
I'll point out two examples of changes in methodology that reflect some of the lessons learned from the crisis. One of the big surprises in the crisis was that real estate markets, mortgage credit quality could decline extremely rapidly and across the entire nation within a very short period of time, and the ability to refinance a loan, which had been generally widely available, would suddenly disappear in nearly a blink of an eye. This was a change in the environment for mortgage credit that was beyond the range of our expectations. We consider a lot of scenarios, some of them positive for the outlook for mortgage credit quality, many of them negative, and we have a whole distribution of scenarios that we're contemplating when we evaluate the risk of a mortgage-backed security. But the particular experience of the last few years was outside that range. We were not alone in being mistaken about this. Most observers of the market, I would say nearly all observers of the market, were completely surprised by what happened. But having been so surprised in this particular instance, we recognize now that in all our methodologies, we must allow for a greater possibility that outcomes well beyond our normal range of expectations could be realized in a short period of time. So that's one area of change. The other area of change would be in our expectations of what issuers of mortgage-backed securities would be providing to us when we rate a mortgage-backed security. While it has been standard always for issuers of mortgage-backed securities or their underwriters to provide representations and warranties that the loans underlying the mortgage-backed security met certain minimum criteria or were described accurately in their offering documents, the ability to enforce those representations and warranties was not as strong as it turned out it was needed to make them effective. We are now requiring much stronger representations and warranties, so if a loan defaults underlying a mortgage-backed security and it is then discovered that that loan was misrepresented in terms of its initial credit characteristics, such as whether income verification had been undertaken by the originator,
but
that
let me ask
loan
this,
would
sir.
have to be bought back by the underwriter, and the issuer and investors would not lose any money as a result.
There were new plans. There were new creative ways of pooling mortgages together that were presented to the rating agencies, and it was described as financial alchemy, that somehow a bunch of lower-rated mortgages bundled together and then some sort of wand matched waved over them, the package as a whole was given a higher rating. I mean, are products like that given much greater scrutiny, or is that process not allowed at all in your firm?
Products that have a subprime collateral or low-rated collateral are given greater scrutiny than they had in the past, because it's been revealed that the performance of those loans, while we always recognize the performance of those loans were going to be worse than higher quality loans, we hadn't anticipated the suddenness in which we could have a radical change from the historical experience associated with those loans and that a simultaneous defaulting across all of them at once.
All right, and I'm running out of time. Mr. McCluskey, if there's time, as it relates to municipal bonds, your concern is primarily the fact that they don't get the process isn't reviewed often enough, or are there processes similar to the ones that have been described last year and in the succeeding year? Are there questionable practices as well as to how municipal bonds are reviewed at the same time?
My concern was with respect to the frequency of the review.
You didn't review and find anything that was similar to the alchemy that has been talked about previously?
No, sir. The municipal bonds tend to be a bit more straightforward than these complex products.
Very good. Thank you.
Gentleman's time has expired. Congressman Chaffetz from Utah.
Thank you, Mr. Chairman, and thank you all for being here. Mr. Chairman, let me just note at the beginning that I, too, would echo the sentiments of our ranking member and the need to dive deep into the Friends of Angelo and Countrywide program. I would hope and encourage, at the very least, Mr. Chairman, is that something that we could potentially vote on in this committee in terms of being able to offer or go after those subpoenas?
You know, as indicated early on, the Justice Department, I understand, is seriously looking at it, and we do not want to interfere with what the Justice Department is doing. But I understand your concern, and I respect the fact that you
Thank you, Mr. Chairman. This committee has done an admirable job in a bipartisan way and to dive into issues of great importance. Just my way of saying, as one member on the minority side of the aisle here, that this would be important and certainly encourage that. Let me get right to Mr. Cantor. Over the last 24 months, as you look at this, did Moody succeed or fail over the last 24 months?
In the years leading up to the crisis...
No, I was just looking at the last 2 years here. Do you think you've succeeded or failed?
Well, the ratings that were put in place in 2006 and 2007 on mortgage-backed securities did not perform as we expected.
Is that a success? I mean, you're a rating agency. How would you rate yourself?
We're deeply disappointed in the performance.
But how would you rate yourself? I mean, what kind of?
We would not give a high grade to this performance in this sector. We were deeply disappointed.
How? You said earlier in your testimony that I was listening here in response to one of the questions, it was about competition, saying that you would encourage and want competition. What are you suggesting then that we do with the nationally recognized statistical rating organization kind of oligopoly that you have? Are you suggesting we break that up? Are we suggesting that we allow more people to compete and more institutions to compete? When you say you're in favor of competition, what does that really mean?
Well, we welcome additional competition If the SEC wishes to approve additional NRSROs, we would favor that.
Do you think you have too much of a grip and a stranglehold on that process and being able to, and this oligopoly that exists between the different agencies?
I don't think we have any influence on that process. We don't have any influence on the SEC's process.
But, I mean, you say on the one hand you want more competition, on the other hand, and you say that you give yourself not a very high grade. Is that compatible with the current model that we have with the NRSROs?
Right. Well, I think we had a lot of company in failing to anticipate the depth of the mortgage crisis.
Yes.
So I expect when investors look at our ratings and think about their utility, they're reflecting on the long historical track record that we have, the performance of our ratings in the corporate sector and the municipal sector and other sectors during this crisis, and it's not limited to the performance of mortgage-backed and mortgage-related securities.
Do you said that you're increasing the scrutiny that is going on within the marketplace. I think I heard you say that correctly. How many employees do you have now versus, say, 2 or 3 years ago? Do you have more employees or less employees?
We have a few more employees.
Like a few more. Help me with the numbers here.
I'm really not that familiar with the headcount numbers. I know we've had some expansion in our overall staffing during a period in time when the volume of activity has gone significantly down. So during a period of actually reduction in the business, we've actually added employees.
For the people that you're responsible for, give me a sense of how many people that is, and do you have more or
right.
less?
Well, in my area, the size of the credit policy group has doubled from roughly 25 to over 50. We're a key part of our initiatives to improve the ratings quality, so it's been a particular focus, and I'm regularly asked by my boss, do I have the resources I need, and if I need more, I've been able to get it in all cases.
Thank you. Let me keep going. My time is so short. Did you see CNBC's House of Cards?
No, I did not.
You've not watched that program?
I did not.
I'd be interested to hear your reaction if you have seen that. Let me go specifically to the two gentlemen that are to your right. Did Moody's retaliate against Mr. Kolchinsky in September 2007 after he raised his concerns that the company immediately implement its planned downgrade policy for the subprime CDOs, the collateralized debt obligations? Did you or did you not retaliate against him?
I mean,
yes.
Mr. Kolchinsky's allegations have been investigated and have been found to be have no merit.
So why was he transferred in his salary cut after he raised these concerns?
I'm not familiar with the personnel decisions that were made, and certainly not familiar with Mr. Kolchinsky's salary.
You don't have any firsthand knowledge of why he was transferred?
I know there was a reduction in staff in his area within Moody's.
And he just happened to be the guy that...
he was the manager in charge of rating the mortgage-related securities from 2005 to 2007, I believe, and that area was the area of the poorest performance of our ratings, and it was an area that wasn't going to see hardly any activity.
So is that the
forward.
extent of your firsthand knowledge? And may I ask you, please, if there is additional firsthand knowledge that you have as to why he was transferred and why this happened that you provided to this committee?
That is the extent of my knowledge. Totally.
That is the... did Moody's eventually adopt Mr. Kolchinsky's recommended policy after his transfer?
I know there was a policy recommendation made before. I'm not sure when it was, before or after his transfer. He made one policy recommendation that was communicated, I think, to compliance, maybe to others. It was carefully considered and it was adopted, yes.
So it was?
Yes.
So he did give some good advice. Interesting. Okay. Mr. Kolchinsky, sorry, I'm slaughtering the pronunciation of your name, but with Chaffetz, I'm used to that. So did the SEC ever respond to you when contacted them about your allegations of misconduct at Moody's?
They did. They contacted me last week. And
just last week?
Yeah.
So after this hearing was announced, you got contacted?
Yes.
That's amazing. I'm just absolutely amazed. In your opinion, does the SEC's failure to respond to your allegations shed any light on the agency's ability to police the credit rating agencies, as some in the administration have advocated? One of the concerns, Mr. Chairman, that we have, and I know my time's up, is that here we have an agency that is failing to police and dive into instances of alleged abuse when you have whistleblowers like these gentlemen here who've stepped up and done what is essentially the right thing in trying to shed light, and yet they only respond the week before this committee actually calls them to testify. So,
Sir,
I know my time's expired, but thank the Chairman.
Thank you very much. The gentleman's time has expired. Now, call on Mr. Foster of Illinois.
Thank you, Mr. Chairman, for holding this important hearing. One of the major problems that we're wrestling with here are the conflicts of interest inherent in the issuer pays business model for the rating agencies. And I agree with Mr. Olshansky that the best analog of this is how we handle conflicts on the oversight of the accounting industry. And I believe that the best model for going forward may be modeled on the Public Company Accounting Oversight Board, PCAOB. An oversight board like the PCAOB would be constituted largely or dominantly by users of credit ratings and would have teeth. Specifically, it would have the powers to set standards, to mandate disclosures. It could conduct spot checks and investigations. It could impose civil fines. It could ban firms and individuals from the credit ratings industry. I believe that the PCAOB has been necessary and sufficient to restore credibility to the accounting industry in the post-Enron era. And so my question is, what, if any, might be the downside of instituting a similar oversight board for the credit rating industry? I guess I'll start with Mr. Olshansky.
Sir, the only downside I could see from that would be the argument of homogeneity of the ratings. In practical terms, that's not much of a downside because with rating shopping and the bankers in charge of selecting which rating agency to go to, they were effectively, there were very few differences between ratings. So theoretically, that would be a downside, but in practical purposes, that was already the practice.
So your reservations are that it might not be a complete solution, but that
certainly
there would be no...
It would not be a complete solution.
Right.
There's no perfect solution to this problem, but I think this is something that allows competition between ratings firms. It allows some minimum standards for the protection of taxpayers and investors, and it allows things to be done in a public, transparent manner instead of being done in back rooms and committee rooms at the rating agencies.
All right. So in general, you would endorse that way forward?
Very strongly. Yes, sir.
Mr. McCleskey?
Sir, the model that you describe also sounds analogous to FINRA, which was the NASD when I worked there. I worked there for 5 years as an investigator, and I have to say that I'm supportive of that model for the reasons that you have already mentioned. I think that you are able to draw on more experience, you're able to pay people more than on government scale when you have essentially a self-regulatory organization. Now, I would point out that, in essence, the SEC backstops FINRA, that there's some shared jurisdiction, and I think that that's a good model as well. The SEC also provides oversight of the self-regulatory organizations, and I think that that should be a legitimate role of such an organization. So I would agree it's not a complete solution, but I would say that it would be helpful. What's the downside? I would say, it's got to be funded. But, some things, my view, having been in this business for quite some time, is sometimes regulation does cost money. It's cost of doing business.
Pure industry self-regulation did not stop the Enron scandals and so on, and that would be the advantage of making it somewhat less than pure industry self-regulation. Right. I guess, Mr. Cantor?
In the list of powers that you would ascribe to this new entity, it seemed to me that most of those powers already reside with the SEC, and I would leave it for others to decide where those, what type of organization is best able to implement those powers, but I would support and continue to support the type of powers that you described, with the exception of a proposal I thought I heard you say that to establish essentially standards for methodologies, which would basically introduce a government agency or a government type agency into the opinion-setting process and effectively stifle diversity of opinion, and would lead to eventually lead to government-based ratings, not privately determined opinions.
I understand. That's an issue that I'm personally conflicted on. There's the usual debate about discouraging innovation versus setting standards. And I think that there's certainly a merit that at least part of what gets reported is based on standards that can be compared side by side for all rating agencies. Anyway, thanks you, and I yield back.
Thank you very much. And now yield 5 minutes to the gentleman from Indiana, Mr. Souder.
I thank the chairman, and I want to join with the other Republicans. I know you're fair. You try to work these things out, but to have a Friend Angelo hearing, I understand the Justice Department is looking at it. They look at a lot of things that we do, but it appears if we don't do a hearing in that very public subject that we're afraid to touch it because it might have involved members of Congress. And I would encourage the chairman to continue to look at it, and would appreciate it if he would do so.
Appreciate the gentleman's concern.
That I have a couple of general comments I want to make, and then a couple of very direct questions that I fear I'm not going to be able to get an answer to. One is that I don't view this as a failure of capitalism. Part of the problem here, as Mr. Issa said, is when you have three companies that have 90% of the market, how does an oligopoly work versus a true competition? And that's really what we're kind of probing in these hearings, because the function of this committee is to look at the past. We're an oversight committee. Other legislative committees look at the future. So, Mr. Cantor, when you say we've made changes, that isn't really enough right now. We have to dig in and find out what happened to see whether those changes are adequate. We had this discussion with Mark McGuire, who didn't want to be here to talk about the past, but we had to understand steroids before we could talk about what we were going to do in the future. And that the whole fundamental premise of capitalism requires accurate information. We believe capitalism can regulate itself if, in fact, ratings are accurate, information is there, and can do that. But in the failure to do that, which clearly there were whoppers of errors here, and we had 5 billionaires on a panel here. When I asked Mr. Paulson, who made the most that year, $3.7 billion, how did you make the money? How did you make that much? Because it seemed to me a lot of the evidence of the housing bubble was there. He said, I bet against all the people who were going the other direction that's how they made $1 billion that year, because they could figure out that the market was about to collapse. And why couldn't the rating agencies figure that out, which are more for the average person is likely to buy based on the rating agencies? And that suggests that very sophisticated analysts could get different information or had either access to information or understood information differently than the basic bond rating agencies. Now, Mr. Issa raised another fundamental question, and Mr. Cantor, you both gave two things that have been frustrating to this committee. One is we never seem to have the right person there to answer the question. And the second part is that in the legal question, it was said by Mr. McCleskey, I think, in his testimony, says there may be civil lawsuits here. And part of the problem in getting all the information is that if you have pending lawsuits, just like in the case of Friends of Angelo, the number one thing that people in my district want to know is if there was corruption or if there was collusion or withholding information, that people go to jail. That's the number one thing. They don't want our committee to trample on that. But the chairman may have to call some people in to let them American people see that there's a refusal to answer the questions because, in fact, there's an investigation. Because my fundamental question is, in Mr. McCleskey's charge, for example, that it was 15 to 20 years that some of these agencies hadn't been reviewed for public securities of cities and towns and so on. Is that true? And have you submitted emails to suggest that you had a debate about that?
You want to know what our surveillance... I can describe our surveillance practices for U.S., local, and regional governments. In
other words, have you submitted evidence to this committee that suggests that he was factually incorrect?
I haven't seen the particulars of what Mr. McCleskey has been asserting, so I don't know whether it's correct or not correct.
So, Mr. McCleskey, you made the allegation here today in your testimony. Have you ever seen any evidence that suggests you were incorrect in your allegation that they hadn't reviewed these securities in many years?
No, sir. I think that by the time I left, there were some discussions about how to improve it, but that, as I recall, there were still a lot of problems out there. And the simple fact of the matter is that you've got tens of thousands of these things out there. In my view, the only way that these can be reviewed at all is through algorithms that will pop up alerts the same way that we do in a lot of other compliance and regulatory
matters. Let me ask you a broader question here, because both of you have made allegations. You were whistleblowers. You have a track record of that. The company's responding that you were inaccurate, that for one reason or another your department wasn't performing well, that's why you're terminated. It wasn't anything to do with being whistleblowers. Well, the only way to check that is because they claim that there was an internal debate. And you claim there was an internal debate. One of the only ways this committee can verify whether there's an internal debate is to get documents from the company that prove that there was an internal debate. And to my knowledge, we don't have those documents. And the question is the reason we don't have those documents is because this is about a lawsuit, that if in fact we found that there were no such documents, that the company would be vulnerable to lawsuits because it would show that there wasn't any internal debate. Do you believe such documents exist anywhere in the system, or have any knowledge that once it matches up, that they had a debate and your argument was rejected, as opposed to the fact there wasn't a debate, and that's why you were filing your complaints?
Well, I think, as I said before, the problem is was anything documented? So there may be, whether there's a debate or not, the question of whether people could provide you documents may be a different issue, whether documents are actually created.
Mr. Chairman, this is a very critical point, because if they can, because the basic establishment question here is that the whistleblowers' charges were just their opinion, and that in fact there was a robust debate and their opinion was rejected and they just made a bad decision about what was happening in the market. Whereas the counter-argument that would say the government does it is basically saying that there was corruption involved. And if there's a civil lawsuit threat here, we may not get those documents. But if there is proof that they actually had an internal debate and they just made a bad decision, that would affect what we would propose legislatively. Go back.
A good point. And that's why we would ask Mr. Cantor to make certain that we get the documents. I mean, I think this is so important. There was a meltdown, and we're really trying to get to the bottom of it, and we need your help in the process. When we look at the fact that Lehman Brothers was rated AAA, AIG was AAA, and then all of a sudden, look what happened. So it's important that, we know. And I'm hoping that you will cooperate, or maybe you feel there's no problem. Do you feel there's a problem?
Problem with what?
You don't think there's a meltdown? You don't? I mean, you've heard of that, haven't you?
The financial crisis has been severe. Yes.
Yeah. And you don't see that you had a role in it in terms of the rating agencies?
During the build-up to this financial crisis, there was a whole chain of events and participants in the markets, of which we were one, that made poor decisions and did not perform as expected. I think we were not alone, and I don't think we were the biggest and most important player in this, but we did misjudge the extent of the coming meltdown in mortgage-related securities.
So that's the reason why we need the documents. Congresswoman Spear from California.
Thank you, Mr. Chairman. Mr. Cantor, I've probably sat in on 200-300 hours of hearings in the last year on the financial services industry. And I come to one simple conclusion. The financial service industry has basically created this structure so that heads they win and tails the American people lose. And it all comes down to something so very basic. Let's start with Lehman. You rated them as a AAA. $2 billion was lost in Lehman's AAA securities by cities and counties throughout this country. Money that they were setting aside because they were about to do constructions on schools and firehouses and the like. And it was just up in air. Poof. The American people really want to have some level of accountability. And I want to ask you if you took action or Moody's took action against anyone who had rated Lehman's as AAA. Was there any disciplinary action taken against anyone?
Lehman was rated single A and was rated through a rating committee process. There were no actions taken against anyone involved in that process. Everything that was done was according to our codes of conduct and
Well, Mr. Cantor, if nothing was done to anyone who rated Lehman as a single A when it was bankrupt, then something's wrong with your methodology. Now, isn't it true that a couple of years ago, your industry, and Moody's was part of it, came to Congress and said, we want to be regulated, but we want you also to pass a law that provides that no private right of action can be brought against us as rating agencies?
I don't recall any such thing. We currently are subject to securities law, and we are subject and can be sued and have been sued.
But no individual private rights of action?
Again, I'm not an expert in legal matters. From my understanding, there are private rights of action.
Let me ask you about this. In Mr. Olshansky's internal memo to Moody executives, he said that the assigned ratings in the Sahara Finance Euro Limited were clearly wrong. In fact, Mr. Olshansky then urged Moody's to stop a related transaction from adding billions of more toxic assets to investment balance sheets. I guess the first question should be to Mr. Olshansky. Did Moody's take any action?
Ma'am, I do not believe the second transaction was rated, as far as I know.
Was not rated?
Was not rated. So the second transaction that I warned about.
And the first was rated, and it was rated at what?
I do not recall at this point. It was an investment grade rating, but I don't recall off the top of my head.
Mr. Cantor, do you recall?
I believe this transaction was rated, and was rated AA3.
AA3. And then what happened to this particular transaction?
It's currently rated AA3.
It still is rated
yes,
as a...
Its rating hasn't changed.
I'm sorry.
Its rating has not changed.
Its rating has not changed. And the subsequent transaction was not rated. And why was it not rated?
I'm not familiar with the specifics of that, so I can't address it.
All right, let me ask you this. One of the big problems that some of us see is that there's a huge conflict of interest, that issuers come to you and ask you to give them consulting services so that when they package their particular issuance, it will be rated highly. So much like the accounting industry where we put firewalls up, many of us suggest that you should have firewalls between your consulting services and your rating services. But it also appears that your compliance staff reports to your general counsel. And the general counsel's responsibilities is to prevent liability for Moody's. But the compliance officers are there to make sure that Moody's is complying with all of the SEC regulations. So it would suggest that you've got, on the one hand, compliance officers who are supposedly making sure that you're following SEC guidelines, reporting to an individual as general counsel who wants to make sure that you have no liability, so there will be a conflict, just very significant. Has that
I believe on the contrary. I believe on the contrary, the general counsel's role is to avoid liability exposure for the company, and there's no better way to avoid liability than to have your employees comply with your regulations and code of conduct.
Well, Mr. Chairman, my time has expired, but I can't understand how you could take qualified people in your compliance section, dump them, and bring people who don't have any expertise in compliance and place them in that role under the general counsel, unless you were really trying to avoid having people who were going to ask questions about how you were doing business. I yield back.
Yeah. Thank you very much. And I now yield to the gentleman from Virginia, Congressman Connolly.
I thank the chairman, and I thank him for this thoughtful hearing. Well, let me pick up on the last exchange between the gentlelady from California and yourself, Mr. Cantor. You said the best